Okay. If Representative Gravely will come to finish his sidebar, yep, we'll come to attention. We'll get started with juvenile justice. Welcome everybody. I know my juvenile court judges here. John Sumner. Are there any other are there any other judges here that we need to recognize? Well, we certainly appreciate you joining us, Judge Sumner, and welcome to Juvenile Justice. We are the third Judiciary Committee here in the House. The first bill that we're going to hear is HB 5. It's going to be presented to us by Chairman Caldwell. Chairman Caldwell.
Thank you, Madam Chair. May I ask these Judge Sumner, Eric John to come up with me?
Okay. Certainly.
Madam Chair, this is HB 5, which I have...
If you would, I do apologize. There are some that are watching online, so if you would, please pull the mic so they can hear. I was actually watching an appropriations meeting yesterday, and it was very frustrating sometimes when people wouldn't do that. I couldn't hear. Yes, that's very perfect. Thank you, Mr. Chairman.
I thought I spoke loud enough that you could hear me in the sawmill, but okay. This is HB 5, but I have a substitute that I had given that I think is now in everybody's folder. And let me explain this bill and what it does and what we hope that this committee will do. There are 94 juvenile judges in the state, and I can personally speak concerning my own juvenile judges, and I was never a juvenile judge, and I do very limited work in the juvenile court, believe me. But I would probably say they're the most worked and overworked judges in the entire state, regardless of what level you go to. In my own circuit, we have two, and they do over 3,700 cases between them a year. So, and of course, as you know, most of their hearings have time specifications on them. They have to have a 10-day hearing or a 3-day hearing or a 20-day hearing or whatever the situation may be. And it's been over 20 years since the juvenile judges have had any type of increase to their grant, as it is called, that is paid. And they're presently paid $85,000 of state funds for a grant that goes to the circuit. And what this bill does is raise that to 110 for a full-time judge. And I know you say, well, gosh, that is a great big increase. And it is an increase, but as you say, for over 20 years, they have not had any increase in it, not 1 cent. And I had, of course, when you have a bill of this nature that asks for funds, you have to have a fiscal note. And so we've had a fiscal note that is, I think Madam Chair has seen, that is $3.4 million would be the increase. And certainly having said on public safety appropriations, which I do, that's a small drop in a bucket compared to the other monies that just in that committee that we dole out. I understand, though, it is still state money. And I would say that all this bill does, and it's specified in it, you'll see what the original amounts were and what I'm asking that the new amounts to be paid for each of the grants. Now, the way this happens, and of course Eric and Judge Sumner can explain it better than I can, but the circuits get a grant. And then that one-time grant, they can use the way they want to pay their judges. Some have just part-time. Some don't have any, except county paid. Others have, like my circuit, we have one full-time that gets this grant, and the county pays the other. Mm-hmm. So this would still just give this money to each judge that is a full-time judge or part-time. Now, I know there's been some question concerning, well, what if next year, though, or 6 months from now, that they appointed 2 other judges? So instead of you having 2 in your circuit, you would have 4. I'm of the opinion that this bill would do exactly what we say. It would not pay those other 2 because we would still have to fund it. And if we didn't send them the funds, they couldn't add 2 more and expect state funds to pay it. Mm-hmm. Now, I've talked with Ms. Travis, of course, legal counsel, and she and I have talked, and she is here today, certainly can answer this much better than I can. So that's the bill, and of course Judge Sumner is here, and of course Mr. John, who you certainly know is here, mm-hmm. that can certainly answer more questions than I can. Mm-hmm. But in a nutshell, that's the bill. You can see, as I say, look at the figures. The done nothing but change the figures and an effective date. Other than that, the bill is identical as to where it was before I came in here today. And I'm happy to try to answer any questions for anybody.
Okay, we'll take a number. Erica, is that you? Number two. Okay. Oh, okay. Mayor Margaret.
Okay.
I am a co-sponsor and I'm for this bill. I have two questions. How does it affect DeKalb County and Cobb County? Because my my juvenile court judge already makes $160-something thousand. So how does it affect my judge?
Excuse me, Mayor Mark. Eric certainly can explain that better than I, but it would not affect them in any way because the extra funds they're getting is from the counties anyway. And the counties can already give, like with Superior Courts, if they want to pay more, they can pay more. If they want to pay a supplement, they can pay a supplement.
So DeKalb County's still going to get the $110,000.
They would get whatever they're getting now. They're now getting 85, but I think with the when they're looking for the 4%, I think it's 88,000 actually, but the statute says 85.
And we have, I think, 3 judges, so we'll get that. Well, so DeKalb County will benefit, but my individual judges may or may not, based on fact that they're already making a good bit more than 110. Is that an accurate statement?
The county would get the same grant. Instead of 88, they would get 110 for the whatever they're getting now.
May I ask one other question?
Sure.
Section 3, beginning on line 43, I thought there was only one, tell me if I'm wrong about this, that there's only one judicial circuit left that a Superior Court judge acts as a juvenile court judge.
That's correct.
So this affects the Ogeechee circuit? What is this? What's the purpose?
If they do not create a juvenile court judgeship, it will not affect them.
I've got a tutor here. Tell me what the purpose of Section 3 is.
Eric, you can explain much better than me. Basically, Mary Mark, what we're trying to do was to hopefully quell some frustration as to what I said a moment ago. Well, a circuit now decides they want to have 4 judges instead of 2. And so I was trying to work in some way to put, I use the term a drop-dead date or a limitation on so that a circuit can come in and say, okay, you're going to pay us 110 per judge. We decide we need 5 judges. The wording may not be exactly correct, but that's the best that I could come up with the help of Ms. Travis, and that's on me, not on her.
It looks like 51 to 53 says a Superior Court judge doesn't have to do juvenile court judge training. Is that what it says?
Well, not in the
For reference, we are talking about LC 297383S.
the supplement. I'm sorry. Look at LC.
It should be in your folder.
297383S. That ought to be in your folder.
I apologize, Madam Chair. Probably.
That's okay. I was provided a substitute earlier today, and for the committee's review, I placed it in the folders.
looks
So
like
we
there
are
are
dealing with
changes in that,
LC29.
Looks like my question's irrelevant. Thank you.
Thank you, Representative Oliver. For clarification, this would be a policy deviation in that you would get a grant. You would get the amount allocated would be per judge as opposed to per circuit. Currently, funds are allocated per circuit, so this would be a deviation from policy that would indicate a per judge allocation versus a per circuit allocation. So that is a deviation. There's also a deviation for each part-time judge as well. So it is a deviation from current policy. So
Right, and it is.
Yes, Representative.
Hey, thank you, Madam Chair. You had mentioned there was a fiscal note. Is there a reason why we don't have that?
I
fiscal
do
note with
apologize. That was an oversight on my part.
Okay.
I was told that there wasn't a fiscal note. I had gotten several. You have several supporting documentation in your folder with regards to the bill HB 5, but we do not actually have a copy of the fiscal note that was placed in your folder. So I do apologize for that oversight.
I have the note here, Madam Chair, if you want it, and I'm certainly share, but cost of state, total state contributions would be approximately $3.4 million each year based on the current count of, and they say 95, but it's actually 94 juvenile judges. And then it says table 1, and it sets out what each circuit and judges get now. And I'll be happy to give that to the chair.
So I do apologize that was actually my error, and I being on public safety appropriations, but sometimes I get a little too much information, so I kind of forget where it needs to go. So I do apologize, but the overall cost would be $3.4 million for the state of Georgia. Any other additional questions?
No,
Okay, thank you. I do apologize, and I think I do apologize, Mr. Chairman, but I do feel like because of my neglect and in neglecting to put the fiscal note in there, I don't think that the committee really has all the information that it needs. So that's on me. So I do apologize. Did anybody else want to speak to the bill? Okay. So we're going to table the bill for now. But I promise you a very quick hearing coming up very soon as I can get that information out to the other committee members.
Thank you very much, Madam Chair. And as soon
Thank you,
as
Mr.
you
Chairman.
can set it up for a vote, you let me know and I'll be here.
I will. It'll probably be early in the morning, committee members. So count on it coming. So I appreciate your patience, Mr. Chairman.
I've got one at 8 o'clock in the morning, but if you call me shortly after that, I will be here. I promise you.
I've already got a subcommittee at 12:30. So, but hopefully we will have that soon. So
Thank you so
I
much.
appreciate it. Thank you, Mr.
committee
Chairman.
members.
Thank you.
Thank you.
Chair now calls HB 886. Representative Oliver, you can present from there. That's fine.
House Bill 86 is requested by the Department of Family and Children's Services based on a federal mandate that comes through based on changes in the federal law in relation to sex trafficking. The federal government appropriately, happily for us, determined to appropriate some dollars for sex trafficking victims, and along with those new dollars that Georgia gets, they wanted to be assured that Georgia DFACS was doing a proper data analysis and proper identification of sex trafficking victims.
Representative Oliver, I do apologize. For some of our newer folk, unfortunately the bill number was not on there, but we are talking about LC 297276 for your reference. It is in your folder, but some people are kind of reading around looking for that House bill number, so I wanted to provide the LC number. It's LC 297276, which is what we're currently hearing. Please continue, Representative Oliver.
Requested by DFACS as part of a federal mandated funding package. I think that we in Georgia already do this. We already identify sex trafficking victims, but this is not going to add, in my judgment, any additional work for our data collection people. And I met with Ms. Travis and the Council for DFACS about the specific way in which we're meeting this mandate by adding a definition of sexual servitude, the criminal offense, in addition to the paragraphs relating to mandatory investigations.
Okay. Thank you, Representative Oliver. Are there any questions from the committee? Representative Raffensperger.
Thank you, Madam Chair. Representative Oliver, thank you for bringing this bill. Right now, what would a sex trafficker get for a punishment, and then when it goes over to here, what would be the increase in penalty? Or
this is not an increase in criminal penalties. The criminal penalties that we have enhanced, when I began this term, the pimping of a child was only a misdemeanor. So in the last 15 years, we've made significant. I think the maximum sentence, I should pull that criminal statute for criminal offenses of conviction of sex trafficking, is at least 30 years at this point. Ms. Travis can correct me on that. So we have enhanced the penalties significantly for criminal convictions of sex trafficking. This provision relates to DFACS investigations only and not relating to the criminal offenses or the sentencing in relation to criminal offenses.
thank you for bringing the bill.
Thank you, Representative Raffensperger. Any other questions from the committee? The chair will entertain a motion from the committee. What is the will of the committee? There is a motion to pass from Representative Evans. I'm sorry, Minority Chair Evans. I do apologize. So there is a motion to pass. Is there a second? Multiple seconds. So there's a motion from Minority Chair Evans, multiple seconds. All those in favor of the bill LC 297276, please signify by saying aye.
Aye.
Any opposed? Bill carries. Thank you so much, Representative Oliver, for presenting the bill. The third thing that we will hear is HB 250. Does she have something for me? Okay, never mind. Okay. Representative Gravely. I'm sorry, what? Okay, all right. I'm sorry, can I borrow yours? Okay. We are talking about LC 336840 is the LC number for HB 250. Be at ease for just a moment, please. Thank you. As the chair is carrying this bill, she will be turning the reins over to Chairman Welch.
You want to stay there? We can swap seats.
Okay. Yep. Let's swap.
Chairman Ballinger, go ahead and present your bill.
Okay. Thank you, Chairman Welch. For reference, we are talking about LC 336840. I will direct your attention to lines 27 through 32. Further, any adult person that provides care to children placed in the home in lieu of such application, the agency or licensed applicant may submit evidence satisfactory to the department that such adult person is an employee or early care and education program as defined in Code Section 20-1A-2 and has received satisfactory fingerprint records check determination pursuant to Article 2, et cetera, et cetera. There's no more than 24 months old, not 24 years. Good grief. So anyway, this actually arose, basically, there was a difficulty that actually a kind of a part-time constituent of mine had. So I'm going to let her kind of tell her tale, kind of the genesis of this legislation. So I will ask Ashley Groom if she'll come forward.
All right, Ashley, go ahead. You want to sit at the table there? And there we go. Got you turned on. Thank you for joining us today.
Thank you, Madam Chair, and thank you, members of the committee, for taking the time to hear this very important issue today. My name's Ashley Groom, and I know I'm wearing a lobbyist badge, but this is not for a paying client. This is the life that I've been living for the past few months, and the things that I've sort of uncovered as problematic that I thought we might be able to fix here this legislative session. So on November 1st of 2016, I got a call that changed my life. I'll probably start crying. But my two nieces were taken into state custody and placed with us. And obviously we did not expect it and had not planned for it, but opened our hearts and our home and are very grateful to have them. One of the first questions that I asked the caseworker is who can help us. And what I learned very quickly was there was nobody, not even my parents initially could help, even though they were the biological grandparents. They had to get background checks. They couldn't transport the children. It took about a month for my parents to get approved, where I was spending 4 to 5 hours in the car getting them to their home school and trying to work and trying to take care of my toddler. It was a very trying time. So one night I was talking to my husband and I just sort of had an epiphany. I said, you know, the babysitter we've used for my 3-year-old is a teacher. And surely as a teacher, she's had a background check. So maybe we can turn that in and have some help. And he thought, that's a great idea. So I called the babysitter and she said, you know, I just got renewed. December 1st, she got renewed. So it was very fresh. She had just gone and had it done. So she sent me the paperwork. We sent it over to DFACS and got a call back that said, sorry, we don't accept other agencies' background checks. And I thought, this can't be right. This is ridiculous. We're all talking about caring for children, and what's good for the goose should be good for the gander. These kids should be safe, whether they're safe at school or safe at home with a caretaker that takes care of them at school. So I called the person who said that we couldn't do it, and she, you know, very flat out said no. And in addition said, and by the way, we only have 13 people that we can do these checks with, so there's a backlog. So even if you have her take off work and come in, I can't tell you how long this is going to take. You know, and with my parents, I'd already gone through that and knew it had taken about a month. So here we are back to square one. And I said to my husband, I think we could probably change this law faster than we can get her background checked. So that's basically why we're here. When we originally went to Legislative Council, one of the first things that they raised is there are, the FBI has certain regulations that they need to be able to comply with. And the reason it's drafted the way it was is to avoid the issue of sharing criminal history. So they have to just accept that the background check that they passed, they're not exchanging any sort of personal information other than that, which helps avoid the issue that you hit with the FBI. So that's basically, you know, pretty simple bill. If you're approved to care for kids by one, you should be approved to care for kids by all and help foster kids and foster parents have support across the state.
All right. Any questions for Ms. Groom? Okay, very good. Thank you. All right. Madam Chair, do you want to take questions from the committee now?
I'll be more than happy to take questions from the committee if anybody has any. I thought it was important that they hear kind of the impact that this has on people day to day and kind of the genesis of this bill and why it's a permissive. It's a permissive in that it allows for greater flexibility for people that are working to really improve the lives and make children's lives better in the state of Georgia. So to me, it's really important. So,
and I'll take a point of personal privilege here that it's two things. One, that the issue of background checks and the ability for agencies to communicate amongst themselves with respect to a volunteer or an employee or a contractor's criminal background has been an issue that we've been debating in some circles for. Mary Margaret's been doing it for a lot longer than I have. But it's a reoccurring issue that we're running into, and it's clearly a roadblock to the successful placement of children. It is a roadblock or it is a financial detriment to a lot of entities that provide child care. And so it's another cost that's added on to what they have to incur, which means that those children or that money that would otherwise be going to the children is going to an administrative function. So this is an issue that's kind of been under the surface of the Gold Dome for a number of years, and a lot of folks have worked to try to resolve that. This is another step in that direction, and I think it's kind of overdue in a lot of ways. With that, we have a question from Representative Cox. Is that right? Or okay.
Erica has that.
Oh, Eric. Sorry, Erica. Go ahead.
It's okay. Maybe you couldn't see me all the way down here.
No. I know I said the wrong button.
So, Mr. Chairman, I have a quick question for you.
Sure.
On line 32, I just want to clarify. It says that it's no more than 24 months old. So, if the caretakers, in this case the babysitter, had taken the background check and it wasn't as recent as the one that was taken now, if it was 20 months old, it would still be able to be taken into consideration. And how, if we knew, if they did take it into 24 months and then maybe a month later something did happen to where they did commit a crime, how would we be able to take care of that? How would we know if that crime was taken, if they're taking it every 24 months?
I think that would go back into the Rat Back program that we've been talking about, Mr. Chair. Right now, I think I do apologize. I'm a little bit of a jumble because there is actually a Rat Back program bill that is being contemplated at the current moment. Okay. So my information may be a little bit muddy, and I'm not really exactly sure how that would. But I think the same would be true right now, absent anything like that, of any background check, whether performed by the department or not.
Okay, thank you.
Representative Thomas, I think that's currently there is no automatic update. So the wrap back legislation that she's talking about, Jill Travis and I and others have been working on having a system that would automatically update the agencies to notify them if they have an employee or a contractor who, just like you said, she qualifies and passes a background check today, but tomorrow that may not be the case. And so having that automatic update would help to ensure that that the children that are being, children or even adults that are in adult care, that they're being taken care of by people that have not committed a crime that would incline them to do harm to those individuals. So I think your point's well taken, but under the current law, we don't have that automatic setup yet.
Yeah, for teachers or anyone. So.
Wow. Thank you.
Thank you. Thank you for the question. It was very good.
Okay, Representative Rasberger. No, Mike Gravely, who's that? You 24?
Yes, sir. Thank you, Mr. Chair. I would just, I guess, a point of personal privilege to just say I'd commend Mrs. Groom. I'm aware of a lot of kids in situations where there is a family member, but maybe it disrupts the routine of the family, or maybe it could be an inconvenience. So the kid ends up not being able to stay with a family member. So I would commend you for going above and beyond to maintain that these children stayed with their aunt.
Other questions from members of the committee? All right. Madam Chair, we have a Virginia's Pryor, I think, signed up to speak on HB 250. Ms. Pryor, if you want to use the podium, I'll turn that on.
Sure. Thank you.
Thank you.
Good afternoon, Madam Chair and members of the committee. I'd first, if you wouldn't mind, like to thank Representative Oliver for bringing the bill, House Bill 86, and I'd like to thank the committee for hearing it. With regard to House Bill 250, what we'd first like to say is that we've had an opportunity to speak with Ms. Groom, and we understand and support the intent. We do have some concerns with regard to unintended consequences that could negatively affect child safety. So what we would like to do as we go back and do some fact-finding around it, we would like to include DECAL and talk to them about their process for ensuring safety in their background checks, and get information and ensure that our understanding of what they do in their background checks is accurate and in line with us. And if they are, and if you have any questions for DECAL as well, they are here as well to talk about their process if Madam Chair desires to hear about them. So.
Okay. Is that Representative Holcomb or Mary Margaret? Okay. Representative Oliver.
Can you tell me a policy reason that we would not accept a background check for a pre-K teacher instead of a background check for a foster care parent? What's the policy consideration?
There are some instances where, and again, we have to walk alongside with DECAL, so I don't want to misspeak in terms of what DECAL looks at, but there are some things that we may look at when a criminal background check comes back around, a DUI, for example. And in some instances, DECAL won't look at a DUI, but for us, in
Do you
terms of-
know that to be true? So you've already compared your process with decal or
We've
not?
had minimal conversation with decal, and what I do understand is that they do not take into consideration DUI, whereas the division, we would, because if you're transporting a child, we need to know if a DUI could technically negatively affect the safety of a child. So that is something that we do take into consideration.
If the family had not, I'm not using her personal situation, I'm talking more generally. In a family rescue situation, if the family aunt had chosen to say, please place the child with me and I don't care about foster care money, you would have placed the child with them without a background check. Am I right?
No, actually,
I think I'm right.
I'll go back and in all honesty, I will go back and check, but my understanding is our policy that we would not do that. If the family has, if there's no involvement with the department and it's a private, no, we would, because we wouldn't have any involvement. But if there is involvement with that family, even when we go out and we do an initial investigation and we emergency place with relatives, we're still going to do the background check.
I
And a
just
home
have
assessment.
experience with other fact situations where the family steps forward and you're happy a family steps forward. The family's doing the right thing to step forward. It seems to me, maybe I'm wrong about this, sounds to me like there's inconsistent treatment based on whether they're asking for money or not. But maybe I'm wrong.
I will definitely go back just to verify, to make sure that you have the information. But anywhere we have involvement, if we go out and even if we emergency place, we still are going to go back to do the home study, and we're also going to do background check verification. But I will follow up on that, especially based on your concerns around the inconsistencies with that.
Okay.
All right, Representative Cox.
Thank you, Mr. Chairman. I'm just looking at the bill, and on lines 28 and 29, it speaks to the application of such a person who's wanting to step up and help. That would have to be satisfactory to the department, that the evidence, that their background check had been completed. I mean, it's pretty broad language. I mean, so they're having to submit evidence satisfactory to the department that they've had a background check completed. I mean, doesn't that language satisfy, or could it not satisfy your department's concerns in having some sort of oversight or say that background completed is satisfactory to your standards?
I apologize, I don't have a copy of the actual, thank you. Okay, that's, so sir, in looking at that, we would still have to get the background check and the information that comes back in the background. I mean, even when a check comes back and it says it's passed, we're still going to, take a look at that criminal background check to see what information is in there. I mean, there could be detailed information in there that the department or the division will look at if it puts a child in a dangerous situation. So.
A follow-up question, Mr. Chairman. Is there anything in this bill that would preclude the department, say the bill successfully becomes law and the situation similar to what we've heard today occurs, is there anything that would preclude the department from conducting a background check or requiring an application for its typical background check after the fostering has begun and occurred, so that if your agency found something that was a red flag to yours, could you not step in and say, we've determined that our background check precludes you from being able to provide foster services? Maybe something occurred, a criminal incident occurred very close to the time that the fostering began by the third party. I mean, so I guess what I'm getting at is, I'm just kind of asking, but I don't see anything in this bill that would really limit the department's ability to continue business as usual. What it would do is just provide an option so that these kids get care that they need more quickly.
You know, I agree that, you know, I think it is important for us to ensure that children get the care in a timely fashion and the things that they need. You know, as I stated earlier, you know, what we would like to do is have the opportunity to work in partnership with Ms. Groom. We would like to work in partnership with DeKalb so that we could have some uniformity. I think there are things in there, it was mentioned around the 24 months. So we would like an opportunity to have some discussion around maybe tightening that time frame so that we can look at concerns around, again, I use a DUI because I think a DUI is a classic example of something that would happen, because with families there's transportation. We do have reasonable and prudent parenting, which that is something as a part of our policy that we do. And so I think there's a great opportunity for us to go back, you know, and take a look, to make adjustments and to work in partnership with Ms. Groom, so that not just for her, but so that we could change the process for all foster parents and those who step up to support children.
Thank you, Mr. Chairman.
Madam Chair, Representative Wilkerson has a question. Do you want to go ahead and field it? Manny, do you want to go ahead and David Wilkerson has a. Okay.
Thank you, Madam Chair. So I guess just to make sure I understand, I guess your concern is that there's a difference in the background checks that you perform versus maybe a DeKalb. Is that correct?
There are some differences in what they require in their background checks versus ours.
Is it possible to identify those differences, and how long would that take for you guys to do that?
I mean,
could you do it quickly?
I believe that we can do that quickly. I mean, as I said, our partners, DeKalb, they're actually here today. And we are definitely willing to sit down with them as quickly as possible so that we can go through and align what we look for and what they look for and see if we can meet somewhere, you know, in the middle.
One last question, if you don't mind.
Yes, go ahead.
Okay. So I guess is if we were to pass this, is there a risk that if you took their background check to start the process, that someone could actually take longer because by the time you started to review the file, you realized that there were things different in the background check that you would have to kind of start the process over again? So is that a concern that you may have?
It is a concern because what we would get was it would just say that it was approved. Mm-hmm. It wouldn't provide us information in terms of what came back in that background from DeKalb. So it would just simply say approved, but there could be something on there that DeKalb might approve in terms of their background check. Again, I think the DUI is probably the cleanest example because in some cases, DUI is not going to permit, you know, somebody, you know, providing services or daycare services because they may not be transporting children. But in our situation, a DUI is critical because they are transporting children. Okay. And so.
Thank you.
Yes, sir.
All right. And I think, is it 27, is it, Ms. Chandler? Okay.
Thank you. Is there some reason why DOE's background check could also not be consideration to be aligned? Because, as Ms. Groom mentioned, that was the case there. And I think those background checks are rather thorough.
I don't have that information in front of me right now, but I think DOE is another entity that, you know, we could have conversation with. But with regard to our partnership with DeKalb, and then the child in daycare situations, that was the partnership in the example that we used.
Thank you.
Yes, ma'am.
Representative Oliver.
Based on your study committee about dual investigations with other agencies, I'm remembering, tell me if I'm wrong, that right now, under the current law, this family would be required to pay for two. Who pays for the criminal background checks? And what does it cost? Because you're asking people to do it twice.
Yeah, the individual does.
Yeah, so you're asking the individual to do it twice in this case. And what does that cost? $58?
53.
Is it 55? Okay, $55.
So that's an example about why this bill would be necessary, because obviously both of you are requiring a criminal background check. That's a waste of everybody's money and time. Am I right or wrong about that?
Well, and I understand, and I agree, and I absolutely respect what you're saying. And so I think, you know, in my initial statement, we definitely understand, and we actually support Ms. Groom and in this effort. We just really would like an opportunity to be able to sit down and partner with her and also work with DECAL so that we can streamline this process. I think that it's something that can be done.
Well, having spent a lot of time on this issue, both in study committees with Mary Margaret and others, there's an underlying federal problem that we run into, and the federal problem is this: is that for the background checks to be completed and for the program to access the federal database to be completed, the Federal Bureau of Investigation requires that all the agencies that are essentially dissimilar in function cannot share those background checks across those agencies. We've tried for 2 years. We've tried. Ms. Fielding is nodding her head back there because she's been on several conference calls where I've almost lost a gasket trying to understand the rationale behind this when you have DECAL overseeing children, DFACS overseeing children, and you have DBHDD, which is also regulating some entities, child care providers that are overseeing the well-being of children. But yet we have tried and we've hit the stone wall with the Federal Bureau of Investigation where they will not allow them to cross-share those background checks. The other problem is what Representative Oliver is alluding to, or sorry, Ms. Pryor is alluding to, is that the agencies do have different standards for what they're searching. So when you search the background check, you don't search everything. You're searching for certain targeted crimes. And not every agency checks for all those crimes. So DJJ has one of the more stringent background checks, so they're actually checking for more crimes than anyone else, and that makes sense. They're in juvenile care, in close quarters, and supervision 24/7. But that being said, I mean, the common sense, which is what you're hearing from this board, is that that system doesn't make common sense, especially in this case. So, and here you have a teacher that's going to be providing care during the day, no different than, frankly, the teacher would be providing at school, except for feeding, I guess. So the supervision is essentially the same. It's all-day function during the day, not overnight. The similarities are plainly obvious, but the system we have is one that has created barriers and silos between agencies when it comes to background checks. The wrap-back legislation that we're looking at, that Jill has been working diligently on, hopefully will help to tear down the silos in a sense that once a background check is done, then another agency, the renewal of those background checks may not be necessary. But just that was to give a little bit of an overview of kind of where this, I think where Ms. Pryor has to hold a line in a sense from DFACS's position. Again, it defies common sense, but that's just where we are regulatorily. Chairman Ballinger.
Thank you, Mr. Chair. I do, I applaud DFACS, and I've partnered very closely with DFACS on several issues. So if it is the will of the committee that this bill does move, we're all feeling a little anxious that crossover day has been moved up to day 28. So if it is the will of the committee that this bill does move, then we will obviously be partnering with DFACS to accommodate perhaps some of their concerns. So.
Okay, so I think in concept still, what Representative Cox has pointed out, I think is true, and that is that the nature of this language still leaves discretion within the agency. So it is not a mandate in that sense. You would have discretion as to whether or not you believe that the information provided is satisfactory. That being said, just keep in mind that there are some there's some limitations on what DFACS can do that is not related to Georgia law. It's federal regulation. So, with that said, is there any more questions from members of the committee? Okay. All right. Do I have a motion? I have a motion from Representative Oliver. And I have a second from Representative Gravely. All right. I'm going to call all those in favor of the motion of recommendation do pass. Say aye. Aye. All those opposed, like sign. The recommendation passes unanimously, and I will yield the chair.
Thank you, members of the committee. With that, I will be contacting you shortly about the HB5 meeting. Hopefully, we will get that rescheduled shortly, but I appreciate everyone's attendance here and your attention to this very important matter, and we are adjourned.